We're talking about litigation. In other words, not only has something gone wrong, something has gone really badly wrong. Not only are you at risk of being fined by the regulator or facing enforcement action, but somebody might actually be going to sue you. And in the sort of litigation that we're talking about this afternoon, the risk is that lots of people might want to sue you. In fact, that lots of people might want to come after you all at once. And I think there's a lot of interest, particularly following the Vidal-Hall case against Google in the Court of Appeal. There's a lot of interest in the possibility of mass data protection litigation involving numerous claimants. So this first slide is really looking at what the possible causes of action are in that kind of mass privacy litigation. What are the claims that people might be bringing? And there are a number of potential claims, and they rather tend to overlap. Under the Data Protection Act, first of all, the most significant potential claim there from the point of view of mass data protection litigation is the compensation claim under Section 13 of the Act. And until relatively recently, there was a big debate about whether you needed to show a money loss in order to bring that claim. And on a literal reading of Section 13, you'd say, well, yes, you do. In the great majority of cases, you need a money loss. If you can show that, that then opens the way to claims for intangible harms like distress or damage to reputation. The Vidal-Hall case establishes that, in fact, the claim under Section 13 doesn't require as a precondition that you should be able to show money loss. If you step back from a moment from the legal detail and think what privacy is about, it always seems bizarre, the idea that you should have had to show a money loss as a precondition. Because, classically, privacy rights are not there to protect, or certainly not solely to protect financial interests. They're to protect more intangible things like reputation, autonomy, dignity, and so on. So that's the data protection route. Of course, Vidal-Hall also establishes that side by side with that, you've got a potential common law claim for the newly recognised tort of misuse of private information. And of course, civil lawyers get very, very excited at the point where they think that a new tort has been spotted or discovered. It's like the sort of astronomer who's discovered a new planet. Remains to be seen in future case law whether, pursuing the planetary analogy, we get a situation rather like Pluto, where somebody decides that this new tort is not a new tort after all. But I don't think that's very likely. Alongside that, you've got the traditional cause of action for breach of confidence, which we've had since forever. Actually, certainly since a case involving Prince Albert's etchings in the early 19th century. Then we've got claims against public authorities, specifically by reference to Article 8 of the Human Rights Act 1998. I must admit, until very recently, I would have thought that post-Brexit, the Human Rights Act and the Convention were probably on their way out in this country. But it's interesting to see Theresa May, who's the front runner in the Tory leadership election, rather backtracking from her earlier commitments to get rid of the Convention and the Human Rights Act. And then all of those different claims, all potentially interacting with managing complaints to the Information Commissioner's Office, and indeed with things like managing criminal investigations and with managing complaints to overseas regulators and possible overseas litigation as well. So when you are handling something like a big data breach, these UK-specific causes of action are only ever going to be part of the picture, and I would compare it rather to playing a sort of game of three-dimensional chess, trying to manage all of these different things all at once.